Lieutenant Colonel Beaver, let me start with you, if I may. Just for clarification, you did not attend the September 02 conference up at Fort Bragg.
No, I did not.
And you really don't know really the purpose of that conference. For example, you don't know if it was recommended there that we use these SEER techniques in an offensive manner. You don't know anything about that, right?
I think what I knew at the time was that the psychological, or we called them the biscuits, the behavioral science team, which was a psychiatrist and I believe a psychologist, would gain benefit by talking to their counterparts at the SEER school, and that also I think the military intelligence contingent that was there on a so-called fact-finding mission.
And is it your view that the purpose of that fact-finding mission was to try to take some of the techniques, et cetera, from SEER and begin to use them offensively against detainees?
To see if any of the techniques should be considered to be used, yes.
Could you put your microphone, Colonel, much closer to your mouth? Thanks.
Sorry.
Yeah, that's an important question. In other words, your understanding at the time was part of the purpose, at least, of that conference was to see if you could apply the SEER techniques to the detainees at Guantanamo.
I believe, based on what General Dunleavy told us at a staff meeting after the fact, after the participants had gone there, that was his purpose, was to find out what could be used, and because he was looking at sending up a request for additional techniques. So yes.
Okay, that's interesting. Let me ask this. In your opening statement, you said, quote, "In short, the interrogation techniques discussed, in my legal opinion, would not have been conducted in an abusive or unlawful manner if the approval and control procedures I outlined were followed," end quote. So are you saying that waterboarding is justified as long as there's the proper controls there?
No, what I meant was I didn't approve anything. I wrote a legal opinion. So whatever the commander, well, as it turned out, the SecDef approved, it would be applied in a manner to prevent it from being used abusively. So the SecDef never approved waterboarding, so it was never anything that was considered. But I did not, I was not the approval authority, and so I think what I was trying to refer to was that an aggressive interrogation had to have a legal review. There had to be a full, the medical team, everyone had to be involved before you could apply a plan, because it has to have a purpose. It can't be sadistic. It has to be for a governmental purpose. This isn't about just doing something because you can. It's about eliciting intelligence.
Okay.
So if we had a plan in place that had been reviewed and approved by the commander, and again, assuming whatever had been approved by, in this case, the SecDef, then you would have a lawful interrogation plan conducted lawfully, not abusively.
Okay. Let me ask you, you've referred to this legal opinion. Are you referring to the October 11, 2002 opinion signed off on by General Pfeiffer?
Jerry Pfeiffer's a Lieutenant Colonel,
I'm sorry,
J2.
Colonel Pfeiffer. Yes. Is that the memo?
That's my legal opinion,
okay.
Yes, sir.
So in other words, you drafted that?
Yes. Ultimately I had some subordinates
okay.
that helped me, but I signed off on the final.
All right. Let me ask, if I can, at tab 7, there's a memo that we've referred to already. It's tab 7. It's a 5-page memo, and I'm going to go right to page 2 of 5. And at the beginning of the memo, it says the following notes were taken during the aforementioned meeting at 1340 on October 2, 2002. All questions and comments have been paraphrased.
Yes, sir. That was done by the Criminal Investigation Task Force person.
And you referred to this with Senator Levin, and that it is a paraphrase, and you don't know how accurate it is. Some of this you don't recall.
Not from 6 years ago. Yeah. No, sir.
When did you first see this memo?
I think March, before I spoke to the Senate staff.
Okay, so in the last year, sometime this year?
This past March.
Okay. Do you, in terms of, you've reviewed this memo, right?
I've seen it, yes, sir.
And do you have any questions about the accuracy of your statements in there? I mean, do you have a...
There's no way for me to know if my statements are accurate because it's 6 years ago, and there's no way for me to recollect what I exactly said or how the CITF personnel chose to phrase a particular issue or the importance they put on it. So I don't ascribe any malintent towards them, but I'm just saying there's no way for me to say what they are saying is accurate.
Let me ask about an impression I have, and that is on page 3, for example. You come across in this as being eager to have these techniques used. Colonel Cummings says, we can't do sleep deprivation. You say, yes, we can, with approval. And then I think this next statement is attributed to you, although it's not clear. It says, disrupting the normal camp operation is vital. We need to create an environment of controlled chaos. We could go down through some of the statements in here, but at that time, do you remember, were you trying to get to the answer that we could use these SEER techniques against the detainees?
I can say that my counterparts in the Criminal Investigation Task Force were very unhappy with this line of discussion. I offered them always to participate. I offered them to write their own legal opinion, which they never did. They wrote a policy piece, which I understood the policy concerns already, but I never received any legal objections based in the law. So I know that they were all very unhappy with me at that point.
Unhappy with your conclusion?
With me having discussions at all about aggressive interrogation techniques.
In other words, they did not like this policy direction?
No, they wanted the law enforcement techniques only, and so you had the clash of law enforcement and intelligence interrogators, which they saw their role as being the one that should be taken. So,
well, let me ask this, and there's a conversation in here about sleep deprivation, and you're quoted as saying, I mean, again, I know this is paraphrased. I understand. You're paraphrased as saying true, yes, but officially it is not happening. It is not being reported officially. The ICRC is a serious concern, which is the Red Cross. Mm-hmm. So it sounds to me like in addition to advocating this, you maybe were trying to cover this up as well.
No, sir. I was the liaison to the ICRC, and I worked very well with them. I believe, and again, it's hard to reconstruct something 6 years later, if you have someone in active interrogation and then the ICRC visits and wants to see that person, you can't stop your interrogation to take them out and disrupt what you're trying to do. And so at different times the ICRC would be down there, and so they would be there for 6 weeks and leave. So I can only, hazard that what I was referring to is if you're going to do like a more intense interrogation that would last a longer period of time, you had to make sure that you had the time to do it and that you weren't disrupted. And when you say disrupted, in other words, you'd rather not have the ICRC? No, they had access to they talked to all the detainees, but if you're in the middle of an interrogation and they want access to a particular detainee, you can't disrupt your interrogation to have them be interviewed by the ICRC.
Let me ask this because I'm just about out of time. In response to one of Senator Graham's questions, you said that you were not that familiar with UCMJ? It seems.
No, I said I wasn't a military law expert. We have experts in the Army who do this for a living, and my hope was that when my opinion went up to General Hill, that my concerns about military personnel being involved with these aggressive techniques would be appropriately addressed by people who do this full time. We call it TCAP, but anyway, the people that look at these issues and would have the time and the resources to address those issues. But I was very concerned about the military. And this will be my last question, Mr. Chairman. Thank you for your patience. But in your legal analysis at the time, did you look at the UCMJ? Did you look at U.S. law? Yes, sir. Did you look at the U.S. Constitution? Yes, sir. Did you look at the Geneva Conventions? Did you look at the Army Field Manual? Yes, sir. And do you have memos or documents with your legal analysis based on your review of all those materials, and have you provided those to the committee? I don't have, whatever was retrieved from Gitmo, the committee would have. I was not, 6 years later, I mean, I didn't take things with me. It was classified, so whatever I used came from human rights court's opinions, all sorts of things, but that would have been what DOD, if DOD had it, DOD would have provided it. But the legal opinion was what my analysis provided on those issues.
In other